So, the Supreme Court has issued an order in a critical Second Amendment Preservation Act challenge that was pending in front of them. So, let's talk about what happened and where this case goes from here. Now, before we jump into this video, if you guys want to support the channel, one of the best ways to do that is to simply subscribe to the channel. Also, double check to make sure YouTube has not unsubscribed you, because they love to do that, especially on 2 channels. And I also want to thank one of the main supporters of this channel, which is First Form. As you guys know, First Form is an amazing company. They have amazing culture. They are pro-freedom, pro-America. They support the Second Amendment and what we talk about here on the channel, and they have great supplements. So if you're interested, check them out using the links down below, both in the detail section, also in the pinned comment. And if you order something $100 or more, you can get free shipping on that order. And they also have a money-back guarantee. Now, as I mentioned in the intro, in this video, we're going to be talking about a significant Second Amendment Preservation Act case that was seeking Supreme Court emergency review. This is a case dealing with a state SAPA law, and we've discussed this in the past because recently the Supreme Court issued an H-1 order denying a stay, which would have protected Missouri SAPA law. This case recently went back in front of the Supreme Court, and we got an answer finally from the Supreme Court. The Supreme Court, in a recent order list, denied emergency review to this Missouri SAPA case, but this case is far from over. It's not done yet, and there's still something that can happen at the lower court level. Now, you might remember that in this case, the Trump administration continued to argue that the SAPA law is invalid in some of its applications and that the Supreme Court should deny review to this case. However, at the same time, the administration also stated that if the Supreme Court here denied review, the government would in fact release some of the judgment that they received in their favor once this reached its way back into the lower court's hands. Now, this lawsuit we're talking about revolves around a 2021 Second Amendment Preservation Act that was passed in the state of Missouri. That law set the state's interpretation of the Second Amendment and set restrictions on the support and funding that the state would provide to federal agencies in their attempts to enforce federal laws that they believe violate the Second Amendment. The law prohibits Mizzou's officers and agents and government officials from helping federal agents who are attempting to enforce those types of laws. The law also created a civil remedy where anyone could sue a Missouri official if they helped to enforce a federal law that violates the Second Amendment. So the law aimed to give the true enforcement powers to the residents instead of any state official or officers. Now, in this Missouri case, the district court, on review, ruled in favor of the then Biden administration striking down the Missouri Preservation Act in its entirety. Now, in response to that, the state of Missouri then appealed up to the 8th Circuit, and Missouri at that time wanted a temporary stay on the lower court's ruling, which eventually also led them to seek emergency Supreme Court intervention. However, on review, the Supreme Court issued an 8.1 order denying that emergency request for a stay. It was only Justice Thomas who was in favor of stepping in on an emergency basis and granting that stay in favor of the state of Missouri. Now, after the Supreme Court denied that initial request for an emergency stay, this went back in the hands of the 8th Circuit, who then heard arguments in this case and then ruled on it. The 8th Circuit ultimately ruled in favor of the federal government, striking down the SAPA law entirely once again. But now Missouri filed the red, assert the Supreme Court, and once again they were asking for the Supreme Court to step in and strike down those lower court rulings. Now, one of the big things that Missouri pointed out in that petition is that the 8th Circuit essentially said that the structure and potential operation of the Missouri law is valid, but ultimately they struck it down because there was an underlying Second Amendment purpose, which the circuit court did not like. Missouri also argued that the 8th Circuit got the analysis wrong because they found state officials could be sued because the court there believed that the state played a role in enforcement of the law by simply complying with the state law. So essentially, they found there that compliance and non-action and non-enforcement was actual enforcement by Missouri state officials. Now, this law was originally opposed by the Biden administration. You. But then, as we know, the Trump administration got control of the DOJ, and initially the Trump DOJ stalled the response out in this case for multiple months. But then we received their answer, and in that response, the Trump administration continued to argue that the SOPA law was invalid in some of its applications and that the lower courts got the decision correct. However, at the same time, they also argued to the Supreme Court that if the Supreme Court denied review to this case and it made its way back in the hands of the lower court, in the hands of the district court, the Trump administration would ultimately dismiss some of the judgment that they won in their favor, or essentially that the Biden administration got from the lower court. They argued in their response to the Supreme Court that having reevaluated this case, the United States has concerns about whether the judgment below extends too far and enjoins applications of the act that do constitute mere non-enforcement of the federal law protected under the anti-commandeering doctrine. And those concerns are exacerbated by the uncertainty in this pre-enforcement posture about how certain provisions of the acts will be applied, about whether the provisions on which the Eighth Circuit focused are indeed inseparable from the rest of the act. And unfortunately, it seems like the Supreme Court was swayed by those arguments, and they sided with the Trump administration in this case. In a recent order list, the Supreme Court decided to deny emergency review to the SAPA challenge. Now, despite that denial, this case is not yet done, and it will still move forward at the lower court level, as the United States stated in that request for the denial in the Supreme Court. Once this gets back in the hands of the district court, they said that they would be open to releasing some of that entire judgment, and essentially it's up to the state of Missouri to file that motion for the release of some of that judgment. So there may be some ways in which the SAPA law will be implemented while the case moves forward at the lower court level and tries to reach a final judgment. So even though the Supreme Court denied emergency review to this case, it will move forward in the lower court, and the Supreme Court will send this case back down to the district court, the Western District of Missouri. And the U.S. government claims that they will release some of that judgment. And recently a notice was sent from the Supreme Court back to the Eighth Circuit in the district court there in Missouri, who are handling this case. And that notice simply states that the court today entered the following order in the above entitled case. The petition for Rita is denied. So the denial is now, mandated. It's now recognized. And this is now being sent back down to the Eighth Circuit in the lower court to finalize this case and ultimately, move towards releasing some of that judgment that was received at the lower court level. We will now see if the Trump administration stays true to their word or if they're going to go back on their promises. They're not locked into having to release some of that judgment. That's an argument they made to the Supreme Court. The motions are not going to get filed at the lower court level, and then it's going to be up to the Trump administration to stay true to those promises. So unfortunately, the Supreme Court once again denied review to this case and denied getting involved in this type of SOPA challenge. But there's still hope and positive movement in favor of keeping the Missouri SAPA law in place while this moves forward. So that's what's currently happening in this critical Second Amendment Preservation Act case. As we get more information as this develops, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that, of course, is to like, comment, subscribe. All of that helps to fuel the algorithm and tells the algorithm that you appreciate this type of 2A content. Also, you can check out these videos here on the screen, which the YouTube algorithm thinks that you would enjoy and you would find valuable. Again, if you want more 2A content, you can click and watch one of these videos here on the screen. But as always, thank you guys so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.